Normally, it's not a huge deal for an attorney to withdraw from representation or for a law firm to withdraw from representation from a client in the middle of litigation. This happens kind of all the time, and usually it's kind of a mundane affair. But after looking into this particular issue, whatever's going on here smells like blood in the water. Let's get into it. Hey everyone, welcome to Legalbytes. If you're new here, my name is Alyte. I'm a lawyer licensed in California and DC, and on this channel we examine the facts and the law and make reason-based conclusions one bite at a time. So the attorney for Ashley Morgan Smithline, one of the 4 women who has filed a civil lawsuit against Brian Warner, professionally known as Marilyn Manson, for claims related to sexual assault and human trafficking, has now filed a motion to withdraw from the representation in the litigation. I went down a little bit of a rabbit hole to try to understand why Ms. Smithline's attorney might be withdrawing from the representation. And the answer has led me to believe that the stage may be getting set for potential bombshell information to come out that would affect all of the cases revolving around Marilyn Manson and these SA allegations from all of these women around him. Be sure to stick around to the end of this video to understand why I think that. But first, this video is sponsored by Casetify. Fun fact, I am a little bit of a klutz, and it's one of the reasons why running has always pretty much been my only sport that I've ever actively participated in. And that's why for me, it is pretty much essential to have a decent case on my phone. And so I was super happy when Casetify reached out to me about their impact and ultra impact cases. These things are created from recycled and plant-based material, and their Chi Tech 2.0 technology offers drop protection of up to 9.8 feet. Particularly, their impact cases are 6.6 feet drop test approved, and their ultra impact cases are 9.8 feet drop test approved. You can tell the difference between the two because the ultra impact cases have an extra little piece of corner protection. The shock dispersing material is lined inside the case bumper, protecting all 4 corners. And the Ultra Impact case is Casetify's slimmest, most protective iPhone case at only 13 millimeters thin. The cases are also wireless charging and 5G compatible. Now, on top of the essentials of keeping your phone from becoming a dangerously sharp glass object, they have also endless print options. You can either choose from their curated prints like this one, or a personalized case with your favorite font and design layout. Anyway, the Impact and Impact Ultra cases also are made of 65% recycled and plant-based materials. All cases come in 100% recycled packaging and are made with recycled paper and non-toxic soy ink made from soybeans. So if sustainability of a product is important to you, that's quite a plus. And if you go to casetify.com/legalbytes, which is also linked in the description below, then you can get 15% off your order. So be sure to check that out. And thanks again to Casetify for sponsoring this video. So getting back into it, just a little bit of background for this particular issue, because I haven't talked about any of the other litigation regarding Marilyn Manson and these other allegations from other women on this channel yet. I've focused primarily on the defamation and IIED case that he filed against Evan Rachel Wood and Ellwanger Gore. But in these other cases, he's actually the defendant. And these other women have accused him of all manner of things, like I said, having to do with SA, human trafficking, and the like. Those cases were individually brought by the model Ashley Morgan Smithline, the actress Esme Bianco, the former personal assistant to Marilyn Manson, Ashley Walters, and an unknown plaintiff who has filed under a Jane Doe name. An interesting thing to note here is that 2 of these women, Esme Bianco and Ashley Morgan Smithline, have been up to this point represented by the same attorney, Ellwanger. It's an interesting thing to note in representing multiple clients in one case or in similarly related cases can have its own ethical pitfalls, but that's not really the focus of this particular video. The important thing to note here is that both of them have separate cases. They are not parties in each other's cases. They are each third parties to each other's cases. And the reason why that's relevant to this video is because we are talking about the discovery process, and there's a difference between the kinds of discovery that gets requested of a party and the kinds of discovery that gets requested of a third party and the various hoops that have to be jumped through. But let's start with the point that sort of drew my attention into this particular case, or these 2 cases rather, the motion to withdraw. Just within the past few days, Jay Ellwanger, the attorney who represents both Esme Bianco and Ashley Morgan Smithline, filed a motion to withdraw from representing Ashley Morgan Smithline. From the looks of it, it looks like he intends to continue representing Esme Bianco, but there's something about his representation of Ashley Morgan Smithline that has led him to want to withdraw. Now, although both the Bianco case and the Smithline case were filed in federal court, they fall under California law. And so in order for Mr. Ellwanger to successfully withdraw from the representation, he has to do so under the California Rules of Professional Conduct. Specifically, Rule 1.16 of the CRPC. Under Rule 1.16, there are basically 10 justifications for why an attorney can withdraw from the representation of a client during litigation. And in Mr. Ellwanger's motion to the court requesting the withdrawal, he points to numbers 4, 5, and 6 of these justifications. So let's first take a look at what Rule 1.16 says about these three. Number 4 says that a lawyer may withdraw from representing a client if the client, by other conduct, essentially other conduct that isn't otherwise defined by those 10 reasons, renders it unreasonably difficult for the lawyer to carry out the representation effectively. Number 5 says that the client breaches a material term of an agreement with or obligation to the lawyer relating to the representation, and the lawyer has given the client a reasonable warning after the breach that the lawyer will withdraw unless the client fulfills the agreement or performs the obligation. And 6 says that the client knowingly and freely assents to termination of the representation. So in other words, he says that all three of these things are present in this particular situation regarding his representation of Ms. Smithline. She's doing things that are making his job unreasonably difficult. In fact, he even goes so far as to say that she has breached the retainer agreement that basically is the agreement that governs the course and scope of the relationship that they have, the working relationship that they have, what he promises to do for her, what she promises to do for him in return, and basically says that he's given her an opportunity to correct those breaches and she has not fulfilled those. And he's basically saying that she has agreed to terminate the relationship. So what does Mr. Ellwanger say specifically about what has happened here? First, let's take a look at the motion itself. The first portion of it is talking about the legal reasons for withdrawal and all that kind of stuff. So I'm going to skip through that and get right to what he says has happened. Starting on page 4 of the motion, at line 4, he says, as evidenced by the declaration of J.D. Ellwanger, filed concurrently herewith on or about March 19, 2021, plaintiff engaged Ellwanger Law, LLLP, to represent her in preparation to file the above referenced lawsuit, the retainer agreement, which was filed on June 29, 2021. Plaintiff's conduct has rendered it unreasonably difficult for counsel to carry out the representation effectively. Specifically, plaintiff has breached paragraphs 9 and 16 of the retainer agreement, which govern the duties of plaintiff to Ellwanger Law, LLLP. Now, it's important to note that he has not attached any copy of the retainer agreement, so we don't know exactly what paragraphs 9 and 16 say. And this is really because of the fact that this is a confidential agreement between the two parties. The court may request to see it, so they may request an in-camera review of the retainer agreement, but I don't see them requiring him to file it because, like I said, that's a confidential agreement. And so an in-camera review would allow the court to review it, to look at it in person, and then hand it back without making it public information. Anyway, back to the motion. Then he says, counsel provided plaintiff a reasonable warning after the breach that counsel would withdraw unless plaintiff fulfilled the terms of the retainer agreement. Plaintiff thereafter knowingly and freely assented to termination of the representation on or about August 19th, 2022. Counsel provided written notice to plaintiff of their intent to file this motion on August 26th, 2022. Plaintiff will not be prejudiced by the withdrawal. Counsel served requests for production and interrogatories on defendant on August 9th, 2022. Defendant served requests for admission on plaintiff on August 9th, 2022, and requests for production and interrogatories on August 23rd, 2022. No depositions have been scheduled in the case and no documents have been exchanged by the parties. Discovery closes February 10th, 2023, and trial filings are due in May 2023. So that plaintiff may have a reasonable amount of time to secure replacement counsel, counsel respectfully requests a 90-day extension to all outstanding discovery requests by the defendant. Written notice of counsel's intention to withdraw was served on defendant's counsel counsel on August 25th, 2022. Plaintiff does not oppose the relief sought in this motion. Defendant's counsel has indicated that they do oppose the relief sought in this motion. Conclusion. For these reasons, counsel asked this court to grant his motion to withdraw as counsel of record for plaintiff and for a 90-day extension for plaintiff to respond to all written discovery propounded by defendants. So essentially, half of that really was talking about the discovery process. Essentially, what's the status of where things have been requested by either side? And all of that is basically to say that there are certain deadlines that could be coming up for Ms. Smithline that have to do with the discovery process. Generally speaking, when something has been requested, usually they are required to respond within 30 days or ask for an extension within those 30 days. So basically what he's doing here is saying there are some deadlines that are coming up. And so I'm requesting that she get a 90-day extension, 3 months essentially, to have to respond to these requests. That gives her enough time to hire a new attorney, and hopefully that attorney can then provide substantive responses to those discovery requests. But this, of course, brings up the question, those paragraphs 9 and 16 of the retainer agreement. What could those possibly have been? A lot of speculation online has resulted ever since the news of his withdrawal came about. And so this basically comes up with 3 possible theories. It could be money. It could be the fact that his client has not paid him, and that after he requested payment that she did not pay him even after that. Realistically, I think that this is most likely a case under which they are operating on a contingency fee agreement, basically meaning that she's not making payments up front on an hourly rate, but rather he is getting paid a certain percentage of ultimately what she gets out of a settlement or out of a judgment. That typically is the case in civil litigation on the plaintiff side, because a lot of times somebody who is filing a civil litigation case doesn't necessarily have the money up front, but they expect to receive something on the tail end. And so they say, you know, for the risk of taking on this case, I will give you a substantial percentage. It could go from 25% to 30% to all the way up to around 50%, or in some cases more, depending on the agreement between the firm and the client. And typically that percentage would change based on when the resolution to that litigation happens, at which point in the litigation process. In other words, the closer that the case gets to trial, the higher the percentage that the lawyer would likely take, because the more work that they would have to put in before getting to that resolution. But the fact that this motion refers to paragraphs 9 and 16 of the retainer agreement seems to suggest it probably has something to do with something other than money. And this is because a retainer agreement usually has other requirements of a client more than just the requirement to pay the attorney for the services. In other words, there's also a duty of candor and a duty to actually actively participate in the litigation. And there's something about what's going on here that makes me think that it might have something to do with one or both of either of those. A duty of candor is basically just the client's duty to give the truth, the whole truth, and nothing but the truth to their attorney. A lawyer that takes on the representation of any client wants to know the good, the bad, and the ugly of the case so that they know how to properly litigate the case, whether they're on the plaintiff's side or the defense. Knowing that certain bad facts are coming gives the attorney the ability to maneuver around those bad facts or to try to minimize the power of those bad facts. So there are few things that are worse than being halfway through litigating a particular case and then realizing that there is certain information that comes out from your client that they failed to mention previously that is really, really damaging to the case and suddenly makes that case much harder to litigate and really changes the strategy that needs to be taken on that particular case after you've already spent so many resources litigating that case with a different strategy. And sometimes that information is so bad that it kind of makes that case unwinnable. I have been on cases before where the firm that I was at withdrew from representation on that alone. But sometimes a client is just particularly difficult to work with. I will say that many clients prove to be difficult to work with because, after all, we are dealing with human beings that are typically very stressed out because, let's face it, the litigation process is a very stressful one. But some clients make it so difficult that it basically makes your job as the litigator entirely impossible. In my experience, this most typically comes up in the discovery process when the attorney is required to meet certain deadlines to respond to discovery requests made by the other side. In other words, when the attorney is required to provide information, whether they are answers to specific questions or document productions or requirements to produce your client for a deposition to the other side. Responding to those requests always requires the attorney to work with the client, and if the client is nowhere to be found in this process, that makes it almost impossible and really frustrating and really stressful, especially when you have particular deadlines to meet, and there's only so many times that those can be extended. So all of that is to say that a client's participation in the discovery process is crucial for success of that litigation. And if a client decides that they want to disappear on their attorney, this makes it all but impossible to do exactly that. So based on the fact that Mr. Ellwanger does say specifically in the motion to withdraw that Ms. Smithline's conduct has rendered it unreasonably difficult for him to carry out the representation effectively, I would say that this participation element probably has something to do with what's going on here. But fortunately, we're actually able to get even more detail because of the fact that Mr. Ellwanger, as the attorney for Miss Esme Bianco, actually recently filed a motion to modify a subpoena of Miss Smithline. Now remember that Mr. Ellwanger is representing both women in their individual cases, and these women are not specifically parties in each other's litigation. In other words, in Miss Bianco's case that she has filed against Marilyn Manson, Miss Smithline is a third party. So as I mentioned earlier in this video, Miss Smithline has to be subpoenaed in that particular case in order to show up for a deposition. And so this particular motion that was just filed in the Bianco case is basically requesting the court to modify the subpoena that has been issued previously so that Ms. Smithline can show up at a later date for a deposition. Now, we know from the case that Marilyn Manson filed against Evan Rachel Wood and Ellwanger that this particular deposition was previously scheduled for August 17th, 2022. And the reason why we know that is because they talked about how important that particular deposition could be for Marilyn Manson to respond to the anti-SLAPP motions that have been filed in that particular case by Evan Rachel Wood and by Ellwanger. And so what has come to light through this particular filing is that that deposition did not happen. And from the looks of it, Marilyn Manson's attorneys are not too thrilled about it. Understandably so. I wouldn't be thrilled either if I were them. But anyway, the most interesting information that has come from this particular motion in the Bianco case comes from Exhibit B to that motion, which is a thread of emails that has been bounced back and forth between the attorneys on both sides of this case in the Bianco case. And those emails are talking about the scheduling of Ms. Smithline's deposition and some of the reasons why this has been delayed, whether properly or improperly. And so this is where things get really interesting for this specific issue and why I start to think that things are maybe setting the stage for some fireworks later on down the line, and maybe not in the too distant future. Basically, there are two emails in this particular thread that I find most interesting. The first one is from August 25th, 2022, from J. Ellwanger to Howard King, Marilyn Manson's attorney. And it says, Howard, as we discussed last week, we agreed that in order to seek additional continuances of Ms. Smithline's deposition, I would ultimately need to provide you and the court a written assessment from Ms. Smithline's psychiatrist that she is unable to participate in litigation due to the current status of her mental health. For reasons which I am ethically required to keep confidential, I cannot provide this written assessment. Accordingly, I am going to have to file a motion to withdraw as counsel for Ms. Smithline. Please let me know if you oppose the motion. Sincerely, J.D. Ellwanger. Now, first off, there is the point of the two parties agreeing that this psychiatrist's note would be required. Now, why would Mr. Ellwanger agree earlier on and then pull what looks like possibly a bait and switch on the other side as to the psychiatrist's note? Either Mr. Ellwanger was not fully honest about Ms. Smithline's situation and thought he could slide out of it somehow, unlikely because it seems like a short period of time in which he would need to provide a note like that. So why would he cover for his client in that regard? Doesn't seem likely to me. Or he legit had been told by his client that she needed psychiatry help and that was the reason why she couldn't show up for the deposition on the 17th, and that he actually believed her. Then there's this line about ethics, where he says, "For reasons which I am ethically required to keep confidential, I cannot provide this written assessment." Now, there are two potential things that could trigger a confidentiality issue here. One would be medical information, whether it's physical or health information. The other could be the attorney-client privilege. The first one really doesn't seem likely because of the fact that Ms. Smithline is the one who put her mental health at issue by saying that she couldn't come to the deposition because of her mental health. Anytime any party puts their mental health at issue, whether they are a plaintiff or a defendant, they generally speaking open up the door for the other side to examine whether or not that's actually true. Case in point, the Depp v. Heard defamation trial, where Amber Heard claimed that she had PTSD and so had to sit for an independent medical examination. Johnny Depp, on the other hand, never made any kind of a claim like that, and so he never had to sit for an independent medical examination. The other possibility is the attorney-client privilege. This definitely seems possible because there could have been something that Ms. Smithline told him that is relatively sensitive. Anything that she tells him within the course and scope of the representation for purposes in the litigation is confidential. And so he has a duty not to disclose that. He cannot waive that. It's only Ms. Smithline who can waive that right to the privilege. So it seems to me that the confidentiality issue here isn't in the production of a note or even the substance of said note. Rather, it seems like the issue that is triggering this confidentiality falls behind the reason for why she couldn't be produced for the deposition, or more specifically, why she couldn't produce a note justifying her absence from the deposition. In other words, if she had a note to give, it would be handed over. It's the fact that she doesn't have a note to give that is particularly interesting here. Basically, what I'm saying here is that it seems to me that when push came to shove, when pressed on the topic of the psychiatrist note and visiting a psychiatrist and the reasons connected to that and missing the deposition, that Ms. Smithline maybe revealed something to her attorney that he cannot reveal because it was disclosed to him within the course and scope of the litigation, but that is particularly sensitive to her position. If it was good for her position, it would be something that he would have been able to disclose. But the fact that he can't disclose it seems to suggest that it's not good for her position. But this is still a little bit fuzzy for the situation, given that Mr. Ellwanger seems to suggest that it has to do with Ms. Smithline's general ability to participate in the litigation. That's until you scroll a little bit further in this email thread and see a response from Marilyn Manson's attorney, Mr. King. See, on August 29th, 2022, Mr. Ellwanger sent another email to Mr. King asking if they would oppose a motion for protection that they were filing on behalf of Ms. Smithline having to do with moving the subpoena. And on August 29th, 2022, Mr. King responds saying, "What are the grounds? She was supposed to appear 2 weeks ago for her duly subpoenaed deposition, an appearance confirmed on multiple occasions by you. On the day before her appearance, you represented that she had flown to the United States to obtain emergency psychiatric treatment and therefore could not appear. Rather than forcing you to make a motion for protection at that time, we made a professional accommodation to you to continue the deposition date. You promised to nonetheless immediately complete a full document production, representing that you already had the responsive documents in your possession. Apparently, that representation was not accurate as the promised production was not made. You also promised written evidence from the treating professional of Ms. Smithline's medical inability to have attended the deposition. You also failed to provide that documentation. Finally, you promised Ms. Smithline would appear for her deposition tomorrow. You have ignored multiple questions from me seeking confirmation she will appear tomorrow for her deposition. So yes, we oppose and would ask that this entire email be included as part of your motion. Howard King." So according to Mr. King's vantage point, the note from a psychiatrist wasn't so much to indicate that Ms. Smithline was generally unable to handle participation in the litigation process, but rather to excuse her from her deposition appearance on the 17th. In other words, to either say, yes, she was checked into the psychiatry hospital and she was required to be here because of her mental health situation, or something along those lines. So if that's the note that they are asking for, it seems that there are several possibilities for why this note might not be appearing. Number one, it could be that Ms. Smithline didn't in fact go to a psychiatric hospital on the 17th or around the 17th. Second, it could be that she did go to a psychiatric hospital, but that the doctor told her that she didn't actually need to be there. Or third, it could be that a psychiatrist believed that it was beneficial for her to be at a psychiatry hospital and that she in fact was at a psychiatry hospital, but that the psychiatrist was not willing to put their professional license on the line by writing down on a piece of paper that she was required to be there. It's not terribly uncommon for psychiatrists to sometimes be a little bit apprehensive about putting something down on paper for the purposes of litigation, because there could be all kinds of professional pitfalls for them there as well. But either way, if what Mr. King is saying is correct, it looks like what they're actually looking for here is just evidence of the fact that Miss Smithline was properly excused from the deposition. And so if Miss Smithline can't produce evidence of the fact that she had a good reason to not be at the deposition, this could potentially suggest some very bad things for Miss Smithline. Basically, this would suggest that she would be willing to go to very great lengths to try to avoid sitting for a deposition, even potentially going so far as deceiving her own lawyer, who is there, after all, to represent her and make sure that she is in the best possible position for any litigation involved in this case. To begin with, depositions are very uncomfortable. You're being pressed and grilled for hours by the opposite side on all of the strengths and weaknesses of your particular case or the series of events that you are testifying to, because the other side is trying to see what is strong and what is weak on either side so that they can evaluate their case. But if in fact Miss Smithline is willing to go to such extreme lengths to avoid a deposition, it just goes to show that whatever information she has, she really does not want to give it to the other side. And realistically, because she's not only a party in some litigation, but specifically a plaintiff in her own case against Marilyn Manson, at some point she is going to have to sit for a deposition. No court is going to ever allow a plaintiff to get away with not being deposed at all in the case. So looking at this whole situation, in my experience, when a particular party in litigation goes to such great lengths to protect particular information, it usually means that it's very, very damning to them. And really, those evasive behaviors only serve to tip off the other side as to the relative importance of that information to one side or the other. And that in turn makes it all the more interesting to the other side, which means that the attorneys on the other side are going to work that much harder to get it. This deposition was already going to happen at some point anyway, but now I would expect Marilyn Manson's attorneys to ask her not just about whatever it was they were going to ask her about in the first place, but also about the psychiatric hospital, about the circumstances under which she decided not to come to the deposition the first time around, and why it was that she wanted to avoid coming in. So all of that is to say that it's still unclear what information Miss Smithline may have that could be beneficial or detrimental to either side of the litigation, in her case, in Miss Bianco's case, or in Evan Rachel Wood and Ilma Gore's cases. But based on what's been going on related to her deposition, it looks like she is particularly terrified to sit under a microscope. And that makes the information she might have that much more interesting. And that makes it seem like there is blood in the water here. The information that she has could very well be very beneficial to Marilyn Manson, and once he gets it, it could be a bombshell for all of these cases. But those are my thoughts. Let me know what you think in the comments down below. And otherwise, I hope you found this interesting or at least informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you haven't done so already, be sure to hit the subscribe button and the notification bell so you can find out when the next video is uploaded. See you in the next video.